box. Today we're going to discuss the topic of legal opinions, what the contents thereof should be, and the reason for actually writing a legal opinion. First of all, the legal opinion will be requested by a client or a party that wants to institute a litigation process, or just needs an opinion on an agreement. So as you can see, there are various aspects to writing a legal opinion, and not just for legal purposes in terms of going to court, but rather than to enter into or engage in a legal contract or agreement, especially where there might be amalgamation or merger of companies. So there might be various reasons why a legal opinion would be required, especially if the person requesting the opinion don't know the options or need to engage in a proper legal opinion or knowledge of somebody that has knowledge of the issue or topic that they need to address. So let's discuss the contents of the actual opinion that you're going to draft. I'm going to provide a structure that I feel comfortable with, that I also consider to be appropriate, and that would be the essence of the actual opinion. The opinion can be structured in a manner that will be suitable for the issues that you raise, but I'll get into that a bit later while we proceed with this discussion on legal opinions. Now, first of all, we need to firstly discuss what does the legal opinion consist of, mainly in headings, and where and when you will cover certain aspects of the legal opinion. First of all, I prefer that the system that I use, I call it a memorandum of opinion, and then straight after that actually write the instructing person's details, and obviously my own details, that I'm the person writing the opinion. It will also be considered that sometimes multiple opinions might be required in a case. I've had a recent matter where the client was given an opinion by me, but also the client requested additional opinions as it was relating to a contract and enforceability of the contract, and also the implications regarding taxes. So obviously, as you can see, we'll have situations where the opinion will relate to different disciplines of expertise that needs to be applied in writing the opinion. So several experts might need to write an opinion on various aspects of, let's call it the subject of the opinion. So basically there will be different subjects that needs to be addressed. Now, under that, we will go into our first heading, which will obviously be the summary of the facts. I will explain each section in detail a bit later. And then secondly, the legal question. Then thirdly, the application of the law. Fourthly, specific or relevant aspects of the matter that you are going to address in your opinion. And then you'll write the conclusion, and then obviously you need to have reference, and I prefer to put in a proper bibliography at the end, apart from the footnotes that you will put in, so that you can actually have reference while you go through your opinion that you're busy writing. Now let's proceed on the aspects of the legal opinion. The opinion is similar to an article or that needs to be that you are writing. So that's why the references needs to be in there, so that you can substantiate what you are writing about in your opinion. You can't just grasp anything and just say that is your opinion and expect somebody to actually believe your opinion. It is it is unprofessional and it has no value. You must also remember that you're getting paid well for this opinion and that you're being approached for this opinion for a specific reason, as I stated before. Also take note that the opinion is usually confidential, and it's only that information can only be used between the person that wrote the opinion and actually the person that requested the opinion. The only time that opinion will be made available to any third party or publicly is when that necessary authorization has been obtained by the party requesting the opinion. Sometimes you'll find that opinion is given that will be made public, and then that is a different situation. But mostly opinions are confidential, as I stated that before, that it needs to be used for litigation or for a specific reason, and then the contents of that opinion can be used to actually proceed with whatever reason that was requested for. Now let's start with the number one, the summary of the facts, our very first heading. In this section, you will actually discuss the question that was what brought about the legal opinion that you need to address. So basically, you will just quickly state what was requested and why you need to write an opinion and for what reason you need to write this opinion. So that is a summary. So basically, it's the same as when a judgment is delivered by court. Just under the judgment heading, there will be a summary of the facts, and this is actually mostly the same, where you'll do a summary of the opinion that you're going to write for the person that requested it. Then secondly, it's the legal question. Now, here also we talk about the legal principles. Here you'll state which statutes will apply, and also the case law that will be used, and what type of case law, and journal articles. So you make reference to stating that you make reference to journal articles, to case law and tribunals, whichever information that you will find it necessary to use in your actual opinion. That is important, so that the person can also, that is reading your opinion, can see that you're actually going to substantiate your opinion on something, and that something must be some sort of reference, as I said, the statutes or journal articles. Also remember that there are many academics and even judges and also legal practitioners that write articles and journals and even books. You often find that in judgments the reference is made to specific books. To give you an example, surety law, there might be a person making reference to a specific book because that might be authority, or Hartley's insolvency law. That, just to give you an example. So some academics' writings are considered to be applicable, and that's why the courts will often make reference to that. And that will also apply for yourself when you actually write this opinion, that you apply yourself accordingly with your references. Then the application, thirdly, the application of the law or the requirements in terms of law that will apply to your actual specific opinion that you are going to write. Now, in that opinion, you're going to discuss the issues at hand with reference to the applicable statutes. Remember, you mentioned before that you're going to use statutes or make reference to journal articles. So now, in this section, this is where you're actually going to start using and writing your opinion and make reference to those specific statutes and academic writings and the common law principles, and reference to tribunals and how they apply to your actual opinion and the issue that you're addressing. And you will have statutory authorities, like example, the ombudsman of the banking institution. If you've got a complaint, then obviously you'll go and make reference that they might go through to them first, or these CISOs, where the CISOs have to be approached before they can actually go and be in a matter of litigation. I've been involved in such a matter where the court held that CISOs was supposed to be approached before they could be approached, and obviously the matter was dismissed due to that fact that they were not, CISOs was not approached before going into litigation. So these are the type of things already that you can establish that needs to be understood and known when you write your legal opinion, and make reference thereto in your opinion, and also to the authorities on what the essence is of the processes that needs to be followed when you include that into your actual opinion. And as I just explained, they will always be your first instance of reference in a matter where you write a legal opinion on. Then also in this section also you can make up various subsections, especially if your issues that you're addressing in your opinion are very vast and there are multiple issues that you have to address in your opinion. And remember, I mentioned earlier that there are, might be different aspects of the legal opinion where, as I mentioned, the tax and another aspect, that is not where you will address the other legal person's legal opinion, but mostly components of your legal opinion that you can address with the various issues that you have to address in your legal opinion. You will not go and address that points or issues that is not in your requested of you in your opinion, because then you'll be off the topic, and then you might not even be considered for future opinions in your field. Doesn't matter how good you are or what expertise you have in your field. That's very important, because that is your future, and your livelihood depends on this, because the people that actually request an opinion from you trust you for your expertise and skills. So remember, that is a very important point when you write an opinion, to keep to the issues at hand and not go off topic. Coming back to the statutes and case laws and authorities, you will have to make reference specifically to those authorities and journal articles. Remember, you need to be authoritative in terms of what your opinion is, or that you are writing on the topic or the issues that you have to address. And remember, I said, don't go and thumbs up. Nobody is going to take you serious, because you're an expert and you must know how to address those issues and use the appropriate authorities and books, academic writings, journal articles. That's only a list, a few. And always remember on your authorities that you'll use the highest authority available. If there's a Supreme Court of Appeal case law on the topic, rather refer to that. You can make reference to other lower court, for instance, the High Court matters that have been, that judgment has been delivered on the topic, but then you'll obviously discuss the relationship between that, or it's been confirmed by the Supreme Court of Appeal. And obviously with the highest court being the Constitutional Court, you'll make reference to a Constitutional Court judgment on the matter. As you will know, as a legal practitioner, the Constitutional Court is the highest authority when it comes to judgments in terms of a specific matter that they've made a ruling on or judgment on. And so that your reader knows that you've given them the highest authority possible, or information regarding reference in terms of what you've been writing about. Now, the next point that we're addressing here is actually the status or the locus standi or jurisdiction, and all these go in hand. Now you'll ask me, why do we have to consider those points in opinion? You must remember, you might have a person, an individual asking the opinion, an individual that is requesting on behalf of the institution to write this legal opinion, or they need to understand that is that individual, does he or she have the capacity to actually engage in litigation, or, as I mentioned, that engage in an agreement or contract. By meaning capacity, is that person disabled, or there's a disability such as the extent that a person is mentally disabled, yet being induced into something that they cannot do, that is legally not binding in law. Then coming to institutions or entities, the person acting on behalf of those institutions, do they actually have the necessary authority? Has a resolution been issued so that that person can act? So those are all part and parcel, in essence, what is required in the opinion, so that all these aspects, apart from the other issues that being addressed, that those issues are addressed. Let's, for instance, take jurisdiction also, apart from the locus standi I just mentioned, is that if the person requesting the opinion wants to initiate litigation proceedings, where are they allowed to institute litigation proceedings? Are they in the correct jurisdiction? How many jurisdictions are there? Is it a foreign jurisdiction? So there are many aspects that has to be considered. And when I talk about jurisdiction, I don't necessarily mean that you must go and discuss foreign jurisdictions in your opinion. It's a matter of the basis of the opinion is relied on where the person wants to institute litigation. Let's take, then we go to the contract aspect, where a person is engaging in a foreign contract. Then you'll maybe discuss foreign jurisdiction on what will be applicable. So you remember, you must always address the issue at hand in your opinion. Don't go out of scope. I'm reiterating it because it's very important that many people will go outside of that scope. And because you are getting paid for the content and, for instance, the amount of pages, it must be worthwhile the person requesting the opinion that they get proper information regarding the substance of the issues that they need to be addressed in the opinion. Then we go on to the conclusion. Now this part in section, the conclusion is a good indicator of the relief that you specify that, in your opinion, that the litigant is entitled to or not. And I'm stating or not for the pure fact or reason that it might not be in the party's interest to proceed with litigation or the contract, as I indicated before. So basically the whole opinion is there to give answers on questions that the person requesting the opinion for them, so that they have a good indication whether they'll have any success in what they elect to do on their way forward on the matter that you've given them an opinion on. Keep well and keep safe. Goodbye.